you, Mr. Chairman. Thank you for having a hearing on something where I think we could work across the aisle. I want to start at a high level, Mrs. Perlmutter, and then go down from there. I want to start with the directive that the founders gave us in the Constitution for establishing the office that you lead. It said in the Constitution, still does, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. I think it's wonderful that the founders saw fit to put that in there. I'm glad that you're a strong defender of intellectual property and copyrights. But I want to ask you about the length or the term of copyrights in relation to patents, for instance. So in the beginning of our country, 1790, the term for a copyright was 14 years and the term for a patent was 14 years. And now and you could get extensions, in one case 14 years, in another case 7 years. But now patents last for 20 years from the date of filing, and copyrights have grown to be the life of the author plus 70 years. In fact, there have been over 10 extensions since 1970. Can you talk about how we got to this period of time that's over a century, really, in most cases for copyrights, whereas patents are still at 20 years?
Yes, thank you for the question. It's difficult to compare copyrights and patents in terms of duration because the nature of the right is so different. A patent is the ability to exclude others entirely from using your invention for the period of time that the patent endures. For copyright, you are not allowing others to copy your expression. So the copyright does not prevent people still from using the ideas and facts in the work. And in fact, it doesn't even prevent them from using the exact same expression if they came up with it originally without copying from you. So for example, while that seems like it could be unlikely, you could have two people come up with the same melody for a popular song without having copied, or perhaps a design for a textile pattern. So the protection itself is much weaker than for patents. So I think it's difficult to compare them.
But the founders started, sorry to interrupt, the founders started them both out at 14 years apiece. And some would argue that patents have zero term now because the courts have eroded injunctive relief, which, the right to exclude. And so patents, I find it interesting. Now, hopefully we have a hearing on patents too. And I know you're head of the Copyright Office, not the Patent Office. But, patents are harder and harder to enforce these days. But how did we get to what is 70 years plus the life of the author? And how does that serve the constitutional directive to promote progress by securing for limited times?
Well, over the years, the thought was that copyrights should provide a livelihood to authors so that an author who wrote books for a living would be able to continue to create, and the author and his family would be able to be provided for. So there has been some discussion over the years of the copyright term approximating the term of someone's life and the life of their children. That's, I think, gradually how it got to that point. The most recent extension, which was in 1998, which was the only extension during the time that I've been working on copyright, was a deliberate decision by Congress to respond to an extension of copyright term in the European Union, where Europe was only going to give that extra 20 years to American works if we provided a similar term. So at the time, the Copyright Office, the then Register of Copyrights, testified that while there might or might not be strong arguments domestically for extending further, from an international perspective and a balance of competition and payments perspective, there were reasons to do it. So that's essentially how we got to where we are today.
Okay, and we've got 20 seconds left here, so I want to get in another question. My concern is that there will be a sneaky attempt by Congress to extend this beyond 70 years, like let's say another make it 90 years plus life of the author, which could end up being a century and a half, which I think does violate the constitutional directive. Can you tell us today that you will not advocate for an extension to extend that beyond the current period of time?
I have not heard anyone pushing for a further extension, and I would find it very surprising if that were to happen.
Okay, and you would not support it?
At this point, I can say I have no intention of supporting it.
Okay, thank you very much for answering the question. Most people don't do that when they come before us. I yield back.
Gentleman yields back.